The title of my presentation is Rethinking Crime and Punishment, Looking Back, Going Forward, and I'm putting to you today the idea that the principles of jurisprudence found under the Brehon Laws provide a more equitable, just and more moral and socially beneficial means of dealing with crime. It is widely held that the primary objective of governance is to produce a well-ordered, peaceful and prosperous society, and to achieve these ends, society develops institutions for dealing with undesirable behaviour. Our justice system, our code of legislation and our means of enforcement are but examples of these efforts. However, the morally based utilitarian philosophy argues that the correct action to take in any given situation is the one that produces the greatest good for the greatest number of people. Therefore, if we can find an alternative means of addressing an issue, one that would produce a greater overall social benefit, then that is the correct and most moral course of action to take, and society should direct its resources accordingly. Imprisoning members of a society who are convicted of wrongdoing is very well established, and it seems to be rooted in the belief that such a mechanism is necessary if we want to achieve a peaceful society. But do our justifications for imprisonment stand up to ethical scrutiny? Kwame Anthony Appiah, who is the Professor of Philosophy at Princeton University, considered the question, what will future generations condemn us for? And identified prisons to be among the most morally reprehensible features of modern life. Things that were once acceptable in society, even considered necessary, would be condemned today. And Appiah noted that society often has ingrained objections towards change, and the thought of abolishing slavery in America would have once led slave owners to ask, well then who's going to pick the cotton? Objections like these often lack moral fortitude. The Government of Ireland has failed to address repeated criticisms from the Irish Human Rights Commission, the Irish Penal Reform Trust and international human rights organisations for its management of Irish prisons, particularly with regards to the significant level of overcrowding and the process of slopping out that still remains in some prisons today. Coupled with higher unemployment and rates of poverty, the recession has not only led to an increase in crime, but also in the level of fine defaulters who are being imprisoned. The result is a greater strain on an already struggling system. It currently costs €70,500 per prisoner per year, and prison populations have increased 400% since the 1970s. They currently stand at 4,250 people. The Irish Penal Reform Trust states that prisoners are primarily early school leavers and have never sat state examinations, and are 25% more likely to come from a deprived area. So when we consider the circumstances of those who we are imprisoning, the types of offences that we are imprisoning for, the significant burden of cost to the taxpayer, the psychological impact on prisoners, but also on the collective consciousness of a society that imprisons its members, the human rights violations, the levels of recidivism, the serious political and financial challenges, it becomes clear that overall prisons in fact have a detrimental effect on society, and the burdens far outweigh any of the perceived benefits. We should therefore ask, can we afford not to consider radical reform? So we have different rationales for why we punish, and although it is not clear how we as a society prioritise these, we should really reconsider them and ask ourselves, what do we want to achieve from imprisonment? So the rationale of retribution or just deserts holds that an offender is punished so that he gets what he deserves. But the key phrase here is punished, and I would ask, what constitutes punishment? And could it take another form that would be more effective and more socially beneficial? The rationale of deterrence is that we imprison people with the aim of deterring others from committing crimes by making it less desirable. And we also imprison them with the hopes of rehabilitating their behaviour and changing their behaviour to make them a better member of society. But again, recidivism rates, repeat offending rates and the increase in prison populations demonstrates that there's been a serious failure of prisons to either rehabilitate or deter offenders. We also have the rationale of social denunciation, which is merely that we imprison people just to signify our repugnance towards the actions that they've taken. And the last one I'll leave you with is incapacitation, which is the idea that we remove an individual from society so that they can no longer commit criminal acts. But if we're taking people who have committed petty crimes and putting them into an environment with professional criminals, we have to bear in mind that incapacitation is a temporary measure, and they would be released back into society with new skills and new criminal awareness. The sociologist Howard Becker's labelling theory holds that we develop our sense of self-identity based on externalities and how we perceive other people perceive us. So merely labelling a person a criminal can cause them to behave in a stereotypical manner. And the theory also holds that a crime is such merely because the most powerful members of society make a rule and then label any transgressors of that rule as criminals or outsiders. Ex-offenders carry the stigma for life, and there is currently no means of expunging your criminal record in Ireland even after years of good behaviour. The old Irish Brehon Laws, however, reveal that prisons are not an essential element for a functional and lawful society, and more socially beneficial alternatives do exist. Historically, the Irish were renowned for their deep understanding and connection with the law. The Attorney General for Ireland, Sir John Davies, who was actually instrumental in abolishing the Brehon Laws, had this to say of Ireland: "There is no nation of people under the sun that does love equal and indifferent justice better than the Irish, or will rest better satisfied with the execution thereof, even though it be against themselves, so that they too may have the protection and benefit of the law, when upon the just cause they do desire it." See, the laws of a land are an irrebuttable witness to its character. And therefore, for the English conquest of Ireland to be successful, the Brehon Laws needed to be eradicated and replaced with the laws and the courts of the Crown. The attack on the Brehon Laws spanned many centuries, but it survived by the will of the people up until the 17th century, when it was finally stamped out by the oppressive penal laws. In his article documenting the history of the bench and bar in Ireland, Barrister R.W. Bentham noted that the Irish irreverence for law does not stem from sympathy with crime or wrongdoing in general, but rather from the fact that the Irish, who have a longish memory, are aware even now that the law in Ireland is not Irish law. However just it may be, and it was once most unjust, it does not command reverence as a native institution, but simply respect nowadays as an essential part of the machinery of government. Once independence was achieved in Ireland, it was perhaps deemed impractical to revive the old traditions, and the British system of law was retained. So I'd like to just list a couple of the key features of the Brehon Law now and consider any of their possible modern applications. It was a very morally based code of law, and it was very much based around the family. Social structure in Ireland consisted of tribes, which were essentially a sovereign state within itself, and they were made up of subgroups of families. The family shared a group responsibility over their kin and could be held liable in the second degree if a member of their family could not pay a fine. Members could become liable for a secret crime within their community, so it created a vested interest for bringing offenders to justice. The early framers of the Irish Constitution clearly recognised the importance of the family unit. In Micheál O'Carroll's translation of the Gaeilge into the literal English, Article 41.1 states that the state acknowledges the family as the basic moral institution of society, whose rights are more ancient and higher than any human statute. So we develop our moral compass in the family home. We learn about compromise, negotiation and reconciliation. But if we consider the state, whether symbolically or legally, to be representative of a larger family, then we need to ask ourselves, what are we doing when we imprison members of our family? I mean, we know that it is not right for a parent to punish a child by locking them in a small dark space. Also, under the Brehon Laws, crimes and torts were considered as one body of law, and they were all essentially civil in nature. All wrongs were civil in nature. The common punishment for all offences was a fine, which varied in amount according to the degree of malice or intention. Such wrongs were simply defined as a lapse from the standards of personal honour and brotherly kindness. This approach could be applied to our modern system, and I argue that it is a straightforward and logical progression of Lord Atkin's neighbour principle from the famous tort law case of Donoghue and Stevenson, which found the duty of care not to injure your neighbour negligence. Lord Atkins said, making a reference to the second commandment of Christ in the Bible, that the rule that you are to love your neighbour becomes in law that you must not injure your neighbour. And the lawyer asks, well then who in law is my neighbour? To which Lord Atkins replied, persons who are so closely and directly affected by my act that I ought reasonably to have had them in contemplation as being so affected when I am directing my mind to the acts or omissions that are called in question. This neighbour principle can quite rationally extend to acts of a criminal nature. Liability would vary in degree in terms of malice aforethought. It is objectively foreseeable that acts of a criminal nature are going to injure your neighbour, and compensation should therefore be paid to the victim. The moral reprehensibility of an act would not change. They would still be condemned, but now we would consider it more as a breach of a duty and not criminal in the traditional legal sense. This would, of course, require a victim claimant for a cause of action to arise. In fact, and the concept of the state taking the role of an injured party was completely alien to native Irish society, which could be described as an egalitarian participatory democracy without the presence of an executive body. This distinction between moral and what we could maybe call political offences might be considered incompatible with a modern society. However, civic duties are already expected of citizens, and if we consider this in light of the Hobbesian social contract theory, people derive the benefit of the state's protection of their rights in exchange for certain duties. Restitution in cases where there is no apparent victim, such as speeding or licensing or public order offences, should be to society at large and exempt from carrying penal sentences, except where, for example, there is excessive repeat offending, where all other attempts of remedy have failed. And when I say remedy here, I'm talking about tailor-made community service orders, rehabilitation, re-education. I'm talking about new, creative, alternative remedies. The principle of restitution was very strong in Old Irish law, which is in tune with our modern understandings of restorative justice. The aim of compensation was similar to that of modern tort law, and it was to restore the injured party to the position that they were in before an injury took place. However, in the Brehon Laws, this principle was seamlessly applied to acts of a criminal nature also, with a focus on inclusion and dialogue between the parties. The process under the Brehon Laws provided a democratic means for the people to come together to find a remedy. Every possible wrong was calculated according to a fixed ratio, which is like an expanded version of our modern book of quantum, which is used by the Injuries Board in assessing damages. The poetic rationale given in the Brehon Laws was to help alleviate the suffering by sharing in it. And what this signifies is that the Brehon Laws were also quite economically motivated. Another key feature was the idea of an honour price, which enabled Brehons to take account of the rank or position in society that the parties held, and to establish a much fairer, proportionate and precise means of penalty. Each was fined according to his worth, according to his stock, and a man of high rank was always fined more than a man of low rank in a similar crime or similar case. I'd like to just briefly touch here on Richard Posner's economic analysis of law, which argues that all actions are ultimately economically driven, and therefore law should be governed in response to market demands. Like the Brehons, Posner considered criminal offences to be civil wrongs, akin to tort law. But Posner's theory differs, however, as he felt that there was a big place for prisons in society for crimes that could not be compensated, like murder. But what Posner's approach lacks, however, is the sort of moral considerations that we find within the Brehon Laws. Nonetheless, many principles that are found in the ancient law tracts of Ireland are echoed in Richard Posner's analysis, which was considered groundbreaking and innovative in the 1970s. And what I'd like to highlight is that the fact that these approaches to law were in the minds of the Brehons thousands of years before Posner indicates the degree of forward thinking and demonstrates that these old Irish laws, with necessary adaptations, are compatible with a modern society. At this point, I'd just like to concede that as it stands today, a complete abolishment of prisons does not seem feasible. However, we need not go to the same level as the Brehon Laws immediately. By adapting our system in light of understanding gleaned from the past, we can retain the prison system for the most criminally dangerous. Society's ability to punish wrongdoers, retribution, or demonstrate its repugnance, denunciation, would not be diminished. They would only change in form so as to produce more socially desirable effects. Prison would greater serve the rationale of deterrence if it was only associated with serious criminal behaviour. This approach would drastically decrease prison populations and allow for the reorientation of Garda resources. By focusing on rehabilitation, education and training of offenders, human potential, hours of life that would otherwise be wasted in a cell, can be redirected into improving communities, implementing social projects and just improving general overall standards of living. Currently, prisons do not rehabilitate the offender. Upon release, an inmate carries the burden of their experience for life, and it is difficult to readjust to society and function as a good citizen. These reintegration problems mean that we will perpetually have a habitual criminal element that can be potentially schooled in more serious criminal behaviour while imprisoned. To achieve a free society without the need for prisons would surely be a testament to the civilised world, and it is perhaps the next milestone we should aspire to. There is so much more I could go into today if I had the time, but ultimately, Our ancient system of jurisprudence in Ireland is hugely significant. To disregard it is like to disregard the Irish language, our wealth of literature, or even the GAA. We should be proud of this part of our heritage, and we should encourage the revival and respect of the Brehon Laws. In light of the economic and political realities of the day, it is worth looking back to the past for guidance going forward into an uncertain future. Good morning.